Hi, my name is Greg Brown, and today we're talking about the recovery of attorney's fees in contract and other business disputes. Under the American rule, each party to a lawsuit is responsible for their own attorney's fees. A common exception to the American rule is the authorization of attorney's fees by a contract. Now, California Civil Code Section 1717 functions to make one-sided attorney fee provisions reciprocal. So if a prevailing plaintiff in a contract case can recover its attorney's fees, so can a prevailing defendant. However, when can a defendant receive attorney's fees under Section 1717 is not always clear. Ultimately, whether a defendant can recover their attorney's fees under Section 1717 depends on the pleadings, the evidence produced at trial, and the nature of their defense. Now let's talk about when a defendant can recover attorney's fees under Section 1717. A defendant can receive attorney's fees if they prevail in a breach of contract action and there is no dispute that the contract contains an attorney fee provision. Section 1717 also allows a defendant to recover attorney's fees if the defendant prevails by proving no contract exists. If the evidence at trial shows that the alleged contract did have an attorney fee provision, but the defendant prevails by proving the contract did not exist or was otherwise invalid, they may recover their attorney's fees. The tort of another doctrine is another way a defendant can recover attorney's fees. Check out our video on that topic by clicking the link below. Now keep in mind, under Section 1717, if the evidence at trial shows that there was no attorney fee provision in the contract, neither party can recover their fees even if the complaint, the pleading, says otherwise. If a plaintiff pleads a right to attorney's fees, attempts to prove they're entitled to attorney's fees, and loses, a defendant can recover their fees. A party claiming fees under Section 1717 must establish that the opposing party would have been entitled to receive fees had they been the prevailing party. Courts have been clear that this does not require a second mini-trial on the issue of attorney's fees. For more information on this topic, or if you have other business-related issues or disputes, call us today at 714-505-3000 or email us at inquiries@bc-llp.com. Thank you.